Hi there, this is Jay Rodarmel with LifePlan Lawyer. I'm a wills, trust, and probate attorney here in California. So a common question that we get after someone has created their trust is, the bank is suggesting that I name my trust as the beneficiary on my bank account rather than taking the effort to put the bank account in the name of the trust. Is that okay? And the short answer is no, it's really not ideal, and I wanted to explain why in this video here today. So there's a couple of differences between naming the bank account, the trust as a beneficiary, versus actually putting your bank account in the name of your trust or the brokerage account, either way. Both of them would have the effect of avoiding probate. If you were to pass away, if you name your trust as beneficiary, then assets will go to the trust free of court and probate. But the difference of putting it in the trust is you get a lot more protection in terms of things that could go wrong. So as an example, the two main things that I worry about are incapacity, and the other thing I worry about is inadvertent disinheritance. So in terms of incapacity, if your account is in the name of your trust now, you take the effort to do that. If you ever need help in the future, it's the language of that trust which is going to make the bank comfortable that it's okay to let someone else step in and take on that successor trustee role. Much harder if you have an individual account, it's not in your trust, and you expect someone to come help you with that. They're going to have to try and use a document called a power of attorney. And if you talk to any banker, they'll let you know that those are very difficult to be accepted by banks. They're not real comfortable with those documents. They're much more comfortable with a trust. So that's one reason to put things in a trust. The second one is an inadvertent disinheritance. If you think about your own family situation, I'm sure most people can think of a situation where an elderly person was getting to the point where they needed help with their account, and if they went into the bank and they brought their child with them or their sibling or whoever it was, the most likely scenario, the easiest thing for the bank to do is to just add that person as a second person onto the account. And what you have just done in that situation is you've eliminated the payable on death beneficiary, because you've now made that account a joint account, and so all of that money is going to end up going to the particular child who was trying to help. So that's a helpful child. Hopefully they would share the money anyway with the other people listed in the trust. But I've also seen some very unhelpful children who decide, I'm the one who's been doing most of the work, I'm the one who's here helping, and so this is my bonus, is I'm just going to keep that account because it's mine, and never mind what the trust may say. So for all those reasons, please put your bank accounts in your trust, put your brokerage accounts in the trust. Don't rely on beneficiaries alone. My general rule of thumb is, if you can put it in the trust, put it in the trust. The one exception to that is around retirement accounts that are treated differently. But for all of your regular taxable bank and brokerage accounts, please put them in the trust and avoid these situations that can occur in the future. Thank you.